matter of commissioners for His Majesty's Revenue and Customs against Professional Game Match Officials Limited.
Lord Richards will explain the court's judgment.
This case raises once again the question whether someone is an employee and the principles by which that question is to be answered. The question in this case is whether part-time football referees who officiate in their spare time at matches in the Championship League and the FA Cup are employees of the appellant company or whether they're self-employed. The answer to this question determines whether income tax on their remuneration stands to be deducted under the PAYE scheme and the level of national insurance contributions payable by them and the appellant company. There is no statutory definition of employee for these purposes. The same is true of many other circumstances, such as statutory employment rights, which depend on whether an individual is an employee. It is left to the common law to develop the principles by which to decide whether a person is an employee or self-employed. Over many years, certainly since the 1960s, a three-part approach has been accepted. First, the court must ask whether the person concerned has agreed to provide their personal services, i.e. to do the work themselves, for another person in return for a remuneration payable by that person. This is generally called mutuality of obligations, and the answer must be yes for there to be employment. Second, the other person must be entitled to exercise a sufficient degree of control over the work done to be consistent with employment. Third, all the relevant circumstances must be examined to decide whether there is an employment relationship. The appeal in this case directly concerned the first two requirements, on which different conclusions had been reached by the tribunals and courts below. On the first issue, it was argued that because the referee was entitled to cancel the appointment to officiate at a particular match at any time before he arrived at the ground, he could not be said to have been contractually bound to provide his services, with the result that there was not the necessary mutuality of obligations. On the second issue, it was argued that because the referee was required to be entirely independent of any interference during a match, there was not the necessary level of control. For the reasons stated in the court's judgment, which was given on the 16th of September this year, the court unanimously rejected both these submissions. On the first issue, the fact that the referee could withdraw before arriving at the ground did not mean that they were not contractually bound to provide their services unless and until they in fact withdrew. Further, once they arrived at the ground, they were contractually bound to provide their services in return for payment, and there was no need in law for a prior commitment. On the second issue, the court held that control did not require that the putative employer could interfere with the referee's performance of his duties during the match. There was a sufficient degree of control provided by the overall contract terms. There remains the third stage, the overall assessment of whether an employment relationship existed. This requires all the terms of the contract and all the relevant circumstances surrounding the contract to be examined. This includes, for example, looking at the level and nature of the control exercised in the particular case. The court has remitted the case to the tax tribunal to decide whether overall a contract of employment existed with the referees and has given guidance in the judgment on this issue.
The court will now adjourn.